Good morning, everyone. It is March 14th, and this is a work session of the Government Operations and Health Facilities Subcommittee of the Health and Government Operations Committee. This morning, we will do our best to consider 10 bills here in the few days before crossover. Delegate Taveras, I don't see that she's made her way to her office yet. So I told her we would start with her, but let's go ahead to 1501, Lindsay.
Sure. Sorry, I pulled Delegate Phillips to the top when I saw him. So sorry, just a minute. This bill reduces the frequency of performance audits of the Board of Liquor License Commissioners for Baltimore City and the Board of License Commissioners for Prince George's County that are required to be conducted by the Office of Legislative Audits. Specifically, the bill requires a performance audit of each board every 6 years rather than 4 years and 3 years, respectively. There's no amendments. And this bill, cross-file, excuse me, passed the Senate 44-0.
Move the bill.
Thank you. I have a second?
Second.
Thank you, Delegate Johnson. Okay, all in favor of the bill, say aye.
Aye.
Thank you. Any opposition to the bill? Okay, the bill gets a favorable report from subcommittee. Then let's go to 1158. That one looks pretty simple.
This bill repeals the requirement that the Attorney General by December 1st of each year report to the Governor and Legislative Policy Committee on any action taken under the Maryland Defense Act regarding the investigation, prosecution, or defense against any action or inaction by the federal government that threatens the public interest and welfare of the state's residents as specified. The bill also repeals the requirement that the Office of the Attorney General annually publish its annual report and opinions of the Attorney General from the preceding year in a bound volume. Instead, they must publish the information on their website. Finally, the bill repeals the requirement for the annual report to include an itemized statement of the receipts and disbursements of the Attorney General during the preceding fiscal year, and specifies the annual report must also be submitted to the General Assembly.
Thank you. And there's an amendment?
Well, there were some amendments suggested at the bill hearing regarding the library, but as I understand.
Oh, that's right. That's right. The library. We sorted that out. Delegate Alston?
Yeah, my question was going to be about the library's concerns.
Yeah, the library concern, we asked the Office of the Attorney General, and that suggestion ran counter to what they were trying to do. So we're not accepting that amendment.
So the library will the library have access to these reports or not when people need to do research?
Yeah, maybe Tiffany can help us with that. Ms. Clark?
Hi, Tiffany Clark with the Office of the Attorney General. So long story short, the requirement that the library wanted to put in would only be necessary if we weren't planning on binding the opinions at all. And as you see in our testimony, we still do plan to bind the opinions. It's just really we wanted to remove, decouple the binding from the annual report. So we still, like I said, we still will continue to bind the opinions. So their amendment is no longer necessary.
Does that answer your
Okay.
question, Delegate Alston?
Yes.
Okay.
So long as her opinions are going to still be available to the library and for people doing research there.
Absolutely. And anybody else that wants some can request them from the Attorney General. It's just, like I said, we're trying to decouple the report from the binding of the opinions.
Okay, thank you.
Absolutely.
All right, thanks. We had a motion on the bill in a second. All in favor of the bill? Say aye.
Aye.
Any opposition to this bill? Okay, the bill gets a unanimous favorable report from the committee. Delegate Taveras, have you made your way to a
Yes.
Okay.
I'm
And
just plugging in the computer, sir.
okay. Then we'll just go ahead and move on to your bill, since I promised you could go early since we didn't get to you yesterday. So let's do 961, Lindsay.
This bill establishes a commission on new Americans staffed by the Office of Immigrant Affairs to measure and report on the contributions of new Americans to the state and the availability of government services for new Americans. By October 1st, 2026, and at least once every 5 years thereafter, the commission must report to the governor and General Assembly. The report includes a quantitative report detailing the contributions of new Americans and the services available to new Americans, and a qualitative report measuring customer satisfaction and identifying any gaps in the services available to new Americans. There is an amendment that I circulated from the chair that strikes language that it would have required for fiscal 2026 and annually thereafter the governor to include in the annual budget bill an appropriation for the commission in an amount sufficient to carry out the requirements of the bill.
Thank you. Delegate Tavares, anything to add to that?
No, sir.
Okay, do I have a motion on the amendment? You want to move your amendment?
Yes, sir. Move favorable as amended.
Second.
Let's move the amendment.
Move the amendments.
Okay, the amendment's been moved and seconded. All in
Second.
favor of adopting the amendment, say aye.
Aye.
Any
Aye.
opposition to the amendment? Delegate Tavares on the bill as amended.
Move favorable on the bill as amended.
Thank you.
Second.
All right, we have a motion on the bill as amended. All in favor, say aye.
Aye.
Okay, thank you. Delegate Shalega.
I'm opposed.
Okay,
And I see Delegate Kipke's hand as well.
and
And
Chisholm, any other opposition to this bill? Okay, thank you. Let's go. We have all the interested parties here today. Let's just talk about 712 for a moment and give people a couple of minutes to express their concerns, and we may have to come back to this bill. Please introduce the bill to us, Lindsay. 712.
So as introduced, this bill prohibits a custodian of a public record from denying inspection of the part of a public record that contains information regarding a trade secret or specified confidential information unless the disclosure of the information is likely to result in substantial competitive harm to the person from which the information was obtained. The bill also establishes that a custodian of a public record may only deny inspection of the part of the record owned by TEDCO or of specified records of a public institution of higher education if disclosure of the information is likely to result in substantial competitive harm to the entity that owns the information. The sponsors submitted an amendment that requires a custodian to deny inspection of the part of a public record that contains information that customarily would not be released to the public by the person or governmental unit from whom the information was obtained, and prohibits a custodian from denying inspection of confidential information or confidential financial information if the information was submitted specifically in connection with the application for or awarding of tax incentives authorized by the governing body of a county or municipal corporation.
Thank you. And Bob Anton, I know that you had contacted me and you had also spoken with Delegate Rosenberg.
And Delegate Rosenberg has joined us as well.
Delegate Rosenberg has joined us. Let's go to Delegate Rosenberg first then.
Thank you, Delegate Kerr. The purpose of this bill is to provide for access to the information relevant to awarding of tax benefits for development projects. I think that's a fair way to say it.
Rosenberg, you're hard to hear. Like
Okay,
yesterday's
I'll
sub
speak
meeting.
louder. The purpose of this bill is to address a problem that arose in a request from the Able Foundation to seek a certain records related to a tax incentive for a project in Baltimore City. And what we're trying to do now is to make sure that the bill as amended addresses that issue and does not create problems elsewhere for other entities where there is no intent on our part, my part as the drafter working with Able, to interfere or affect other aspects of the Public Information Act and other instances that are not germane to what we're trying to accomplish. So I think if you could give us another 24 hours to meet with the relevant groups, that is giving us a fair opportunity to try and resolve this. so that the narrow purpose of the bill can be attained. That's what I would say.
Thank you, Delegate Rosenberg. Hearing that Delegate Rosenberg has requested another 24 hours to meet with interested parties, does anyone want to weigh in right now very briefly? Sarah Semple?
Hey, yeah, this is Sarah Sample from the Maryland Association of Counties. And so, yeah, we've got a lot of people on the call today, so I just thought, we would go ahead and share some of our considerations, while we're all here. But yeah, we've got a few representatives on the call, from some of our jurisdictions that can speak to any more specific concerns. So I'll just give an overview from the MACO perspective. The major concerns that we identified, and I'll talk about this in terms of the original bill and the amendments, is it's placing a confusing burden of proof on our record custodians, which could result in unwarranted disclosures or denials. And in that case, potentially more litigation and more liability. The lack of a clear definition of standard for substantial competitive harm compounds this issue a little bit. And the custodians also wouldn't have industry-specific knowledge to assess that. But then as far as the types of documents we sometimes review, counties currently have the ability to request and review confidential financial documents and revenue documents from businesses in order to negotiate an appropriate and beneficial agreement based on the wealth and the growth trajectory of an organization. And it essentially helps us establish reasonable and competitive deals on behalf of local governments and taxpayers, and disclosing those documents that are not commonly available to the public, we believe would have an effect on the willingness of a business to share this information, which would put us in a significantly diminished position in these negotiations. So that's the MACO perspective overall, but I would throw it to any of the locals who wanted to share additional thoughts on that.
Can
Okay,
I ask,
thanks,
had you
Sarah.
share? Oh, I don't have the floor.
I'm sorry, Delegate Rosenberg didn't.
Can I ask a question?
Yes, please go ahead.
Had you communicated these concerns to us earlier?
Yeah, we had sent them over to Martha.
Okay, thank you.
Yeah, absolutely.
Let's hear from Keith Wamsley.
Hi guys, Chairman Kerr, hi. Keith Wormsley, I'm here today on behalf of Rocket Mortgage. I want to thank Chair Penyamelnik, Chair Kerr, and the sponsor, Delegate Rosenberg. We had some fairly major concerns about how this bill would interact with the financial services sector and the examinations that go on there. Rocket Mortgage are satisfied that the sponsor's amendments meet our concerns, and we're very thankful indeed for the inclusion. So thank you.
Thank you, Delegate. Oh, Bob Enton, go ahead.
Thank you very much, Mr. Chairman, members of the committee. Just briefly, Robert Enton on behalf of the Maryland Bankers Association and the American Property Casualty Insurers Association. I spoke with Delegate Rosenberg this morning. My concern is looking at the revised language in the last two lines down at the bottom. It says, or as required by the terms of an agreement authorized by the governing body of a county or municipal corporation. That just seems very, very broad to me. So any agreement that anyone enters into with a county or municipal corporation, whatever information you furnish, confidential financial information, whatever, would all be subject to disclosure to the public, and we find that problematic. Hopefully that could be addressed. Thank you.
Welcome. Delegate Hill.
Thank you. And I don't have the amended language. I know Delegate Rosenberg will get this straight, but I just have one question, Delegate Rosenberg. When the information is initially gathered by the government agency, would it help at all if the entity that receives it, who would be in sort of the best, to Mako's point, would be in perhaps the best position to, based on the subject matter, know what's proprietary? Now, can that information be marked as proprietary or confidential, so that down the road, the entity required, to address the Public Information Act would know? In other words, instead of the Public Information Act officer making the determination about what is proprietary, can that be marked at the inset as opposed to being determined at the outset? And if so, would that help?
If I may, my response, not as a litigator, would be that's often the subject of litigation, and that's the purpose of this bill, is to try to resolve that. But that certainly would not be conclusive as to how it was marked initially, because that is often the heart of, that's why there's a lawsuit here that we're trying to rectify.
Okay, thank you, Delegate Rosenberg. Thank you,
Thank you.
Delegate Hill. Alex Hortis, you did have your hand up.
Yeah, thank you. Alex Hortis, University of Maryland, Baltimore. I would echo the concerns of the Banking Association. I don't know what the phrase or related agreement, terms of agreement means. It's not defined. We do a lot of work with biotech companies. We are an economic engine in the state. We generate about $50 million a year in private funding. Some of that is through local and city entities for county entities, including the Institute for Health Computing in Montgomery County, which is one of the leading initiatives, not only of UMB, but of the state of Maryland. And I can tell you, we've already lost agreements when a pharmaceutical company or a biotech or a medical device company says that all of a sudden, they naturally during due diligence turn over confidential commercial information, confidential financial information. And if this bill passes with this amendment, I can guarantee that we will lose many, many more, and it could put a severe cramp on some really exciting initiatives to help, eliminate health disparities, to develop new pharmaceuticals and therapeutics. And for that reason, UMB, I should say, is opposed to this amendment as well.
Thank you. Marta, go ahead.
Yes, good morning. Just to echo, we share the concerns about the language in B, but I just want to express on behalf of State Farm, my client, and other clients who regularly provide confidential information to government regulatory agencies. We have a real concern with what's being added to A, that new language about what would be customarily not released to the public by the person that provided it. I don't know what that means. That changes the legal standard in our view across the board, and we have real concerns with that. If the bill was narrowly tailored to the circumstance that gave rise to the bill, as I said when I testified at the hearing, we wouldn't object. But I think the amendments as they currently sit don't do that. So we would continue to have concerns.
Okay, thank you. Stephen Salisbury.
Thank you very much. This is Stephen Salisbury from the Baltimore City Law Department. A lot of what our concerns have already been expressed. I just wanted to add a couple of points. One, just to point out that, and this is something that I think we had in our written testimony, that this does really deviate from the Supreme Court standard when interpreting the Federal Information Act, the FOIA, and which I think we just, I think it demonstrates, again, in conjunction with a lot of the concerns that other people have raised, this really imposes a standard on both the businesses and on the local governments that, I think is really goes beyond, is going to just have a lot of downstream consequences like the ones that folks have raised today. And I would just add to that, the city, and I know a lot of our other sister jurisdictions are under a lot of strain in compliance with open records requirements that we are, fully interested in working with. But this is going to really, this is just going to add a pretty significant burden trying to interpret some of the portions of the statute that aren't entirely clear. And I think, trying to work backwards from one specific, matter, that's where you're often going to have legislation that is all of a sudden sort of applying much more broadly when it was trying to solve this one specific problem. So I totally understand, the interest and why, the bill may have been introduced, but we just wanted to echo the concerns of others and express the opposition of the city.
Thank you. Lee Beeman.
Thank you. I'm appearing this morning on behalf of the Board of County Commissioners of Allegheny County and our county attorney's office. I'd like to echo the comments that have been offered by my colleague, Mr. Salisbury, and by Mako. And just to emphasize the point that at a time when much of our state is really struggling for economic development, Allegheny County believes that this bill would be a hindrance to economic development. My office in Allegheny County sits literally 300 yards from the West Virginia border, 6 miles from the Pennsylvania border. We're constantly competing with these other states for economic development projects. This would be a hindrance that would cost us economic development incentives because businesses will be hesitant to provide these requests. So for that reason, we would oppose the bill. Thank you.
Thank you. And finally, let's go to Laura Anderson Wright.
Good morning, everybody. Thank you so much for your time this morning. I serve as in-house counsel at the College Park campus, the flagship campus, and I agree with so much of the testimony that has already been submitted in writing, not just by Maryland State Bar Association, but MACO and others. But I want to give you all examples. The University of Maryland College Park was asked to turn over patentable information, proposals submitted to the federal government from a startup company called InventWood. InventWood has been kind of this diamond in the rough that has blossomed into an amazing company. They recently just signed a lease for a 90,000 square foot industrial space in Frederick County. I had to fight with the requester, who was a direct competitor to InventWood, to protect these records. And I was successful, but the way that this bill was initially written, and even with its amendments, put entities like InventWood at risk. When in Montgomery County, where I live, AstraZeneca is investing $300 million in the county. They're coming to Montgomery County because they want to be near UMB and other institutions of higher education. These global companies can go elsewhere. They can go to Pennsylvania. They can go to Virginia. And we lose that competitive edge, that economic leverage that we have to attract new business, to attract jobs. And we don't want language that is more of a chainsaw than a scalpel in trying to address a very particular niche problem. I'll stop there, but I wanted to give you examples, and I can throw in the MEEC, the Maryland Educational Enterprise Consortium. I have a request for all of the proposals that were submitted. This is a statewide consortium that provides members with contracts to purchase IT hardware, software, other tech-related services at a discount. And I doubt those who submitted their proposals would want their technical and financial information simply made publicly available. Why do business with Maryland if we can't be a good partner? Thank you.
Understood. And thank you for helping InventWood to come to my district. Okay, final word, because we know that the bill's going to be held for a day. James Benjamin, go ahead and finish it up for us.
Thank you very much. Good morning. I'm the county attorney for Baltimore County. I would echo the concerns of the prior speakers, but I wanted to add to Mr. Beedman's point with regard to this bill of concern that even as amended, it would could make it difficult for governments to work with businesses if businesses know confidential commercial or financial information would be disclosed, even in the narrow instance where it's being submitted in connection with the application for or awarding of tax incentives or is required by the terms of an agreement authorized by the governing body of a county. I just wanted to add that point and share the county's concern. Thank you.
You're welcome. Delia Rosenberg, thanks for joining us this morning. I hope this was helpful. Thanks everyone else who shared your concerns. We will put it in your capable hands, Delegate Rosenberg, and wait to hear from you.
Thank you.
Let's go on to Delegate Embry's bill, 780.
As introduced, this bill requires state agencies use the competitive seal proposal procurement method to solicit private security services if the contract is expected to have a value greater than $100,000. The sponsor submitted amendments that instead establishes that competitive sealed proposals is the preferred method for procurement of just security services rather than private security services with an expected value that is greater than $1 million, and also delays the bill's effective date to July 1st, 2025.
Thanks, Lindsay. Delegate Embry, anything to add?
I just want to thank the chair. We were able to get consensus among the government agencies, union, and security industry. So I'm very grateful. Everyone agreed to these amendments.
Okay, thank you. And I know, John Pika, that you're here to speak to this bill. Do you want to go ahead?
I think Delegate Embry and Ms. Rowe said what is important. We have, these are consensus amendments that have been agreed upon by MDOT, and I believe Ms. Corsinetti is here, and DGS. So is Ms. Robertson. And these agreements or these amendments were agreed upon in a meeting convened by the chair and attended by Delegate Embry. So we would ask for a favorable report on the amendments and the bill. Thank you, Mr. Chair.
The amendments.
I have a motion on the amendments. Second?
Second.
Okay, everybody in favor of the amendments, please say aye.
Aye.
Any opposition to the amendments? On the bill as amended?
Move the bill.
Second.
Second.
Okay, we have a motion and a second on the amended bill. All in favor of the bill as amended, please say aye.
Aye.
Any opposition to the amended bill? Okay, the amended bill goes forward to the full committee with a favorable report from subcommittee.
Thank you.
Thank you, Mr. Chair.
Thank you for joining us. And now Delegate Phillips, 877.
As introduced, this bill required the Office of the Comptroller to develop and maintain on its website a procurement dashboard that must be public, interactive, and searchable, include specified information related to state procurement, and be compatible with the Comptroller's online payment processing portal for integration of vendor payment data. The dashboard must include information related to the Board of Public Works, meeting announcements, agendas, and related materials, including contract spending amounts and state procurement preference programs. Beginning in fiscal 2026, the governor must include an appropriation in the annual budget bill for at least one full-time position in the Comptroller's office to develop and maintain the dashboard and software necessary to develop and maintain the dashboard. The sponsor has submitted amendments. These are identical to amendments voted on the cross-file in B&T yesterday, 13-0, that require the Comptroller to develop and maintain the dashboard on BPW's website rather than the Comptroller's, requires a governance committee composed of liaisons to BPW from the offices of the Governor, Comptroller, and State Treasurer to review the contents of the dashboard for accuracy and completeness, repeals the requirement that the dashboard be compatible with the Comptroller's online payment processing portal, and requires the Governor to include an appropriation beginning in fiscal 2025 rather than fiscal 2026.
Thank you, Lindsay. Delegate Phillips, I have a note here that the fiscal note was high. Has anything been done to address that?
It's my understanding the governor's office and BPW and the comptroller have decided they will figure out how to deal with the fiscal implications.
And is this also jointly assigned to appropriations?
It is not.
Okay.
I don't recall it being jointly assigned. No, I think it was just assigned to HGO.
Okay, thanks. Delegate Hill.
Yes, I was wondering, Delegate Phillips, is there a letter from the department?
No, I do not believe we have a letter on file from the department. I do know this is moving through the Senate, and so it concurs with the Senate bill and the Senate language. So I'm not sure if they've requested that or not.
So, and the reason I'm asking is if we go ahead and pass it and they don't do it, then we've got a bill sitting there with the high fiscal note. And so I'm leaving it up to the chair's discretion, but I think we ought to have, or Lindsay.
I just raised my hand to note that I've put a request into the Appropriations Committee for approval on the fiscal note. I tried to ask B&T staff since I knew they were voting on this and they're also familiar with the budget, but I didn't get an answer as to whether or not this actually was in the budget. But we wouldn't put this on a full voting list until we have approval from appropriations. But given the crossover timing, I felt like it was okay to put this in subcommittee for discussion, and then we can put it on a full committee voting list again once we get approval back from appropriations.
Move the amendments then.
Well, thanks. That's what my note about appropriations was.
So move the amendments.
Okay, we have a motion on the amendment.
Second.
Okay, all in favor of the amendments, please say aye.
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 All right. Do I see any opposition to the amendment? Okay, on the bill as amended.
Move the bill as amended.
Second.
Okay, we have a motion and a second on the amended bill. All in favor, say aye.
Aye.
Any opposition?
Show me your
Okay,
finger. Show it to me.
thanks. So
I
we've
didn't see
got,
it before. Show me your finger.
and your You need to mute yourself, Delegate Kaiser. Thank you. Okay, this bill will go ahead to full committee, pending the report to see whether this funding comes through. So thank you, Delegate Phillips. We hope it works out well for you.
Thank you. Appreciate the committee. Thank you.
Delegate Forbes, 1486.
Good morning.
Good morning. Lindsay?
This bill alters requirements related to the Cyber Maryland program and fund by requiring that TEDCO administer the Cyber Maryland fund, clarifies the types of administrative expenses that may be paid for from the fund, including hiring staff and hiring consultants and other necessary professionals, removes the requirement to hire specific staff for the program, and removes the provide funding for specific staff. TEDCO is also required to adopt to award grants under the program. There are no amendments.
Delegate Forbes, anything to add?
No, it's a simple bill that was requested by TEDCO to make sure that SB 801 aligns with how they normally run their programs. So I asked for a favorable report.
Well, thanks. Thank you for joining us. Do I have a motion on Delegate Forbes' bill?
Move favorable.
Okay.
Second.
All right, we have a motion and a second. All in favor of the bill, say aye. Okay, any opposition to the bill? Thank you for joining us, Delegate Forbes. Your bill will go forward to full committee.
Thank you so much. I appreciate it.
You're welcome. The number 8, 1206, I'm sorry, 1206, Maryland Ireland Trade Commission.
This bill establishes Maryland Ireland Trade Commission with the within the Department of Commerce to study and promote trade between Maryland and Ireland. The commission must study and make recommendations regarding advanced bilateral trade and investment between Maryland and Ireland, initiating joint action on policy issues of mutual interest to Maryland and Ireland, promoting business and academic exchanges between Maryland and Ireland, encouraging mutual economic support between Maryland and Ireland, encouraging mutual investment in the infrastructure of Maryland and Ireland, and other issues as determined by the commission. The sponsor submitted an amendment to sunset the bill after 2 years.
Okay, I will move the amendment.
Second.
Okay, motion on the amendment and a second. All in favor, say aye. Any opposition to the amendment? Okay, seeing no opposition, will anyone move the bill as amended?
Move the bill as amended.
Thank you. And we have a second on the bill as amended. All in favor, say aye. Okay, any opposition to the bill as amended? All right, thank you. Bill moves forward to full committee. We now have gotten out of order a little bit here.
By my count, you have one bill left, 835.
835.
This-
Yes, okay, go ahead. Thanks.
Sorry, this is a local Calvert County delegation bill that authorizes the Board of County Commissioners of Calvert County to enact an ordinance following specified procedures that give a percentage preference to a resident business that submits a responsive bid or offer that exceeds the lowest responsive bid or offer by a non-resident business. With the preference, if the bid or offer by the resident business exceeds the bid or offer of the non-resident business by less than specified percentage, the resident bidder or offerer may be awarded the contract. There are no amendments. We have a delegation letter, unanimous support on the bill.
Okay, is anyone here to address this bill? I don't think there is. Seems pretty straightforward. Does anyone want
Move the
to?
bill.
Thank you.
Second.
All right, we have a
Second.
motion to second on the bill. On the bill, all in favor, say aye.
Aye.
Any opposition to the bill?
One
Okay,
question.
all right, good. The bill moves forward to full committee.
I think Delegate Hilt
I had a
said,
question. Yeah.
Oh, go ahead, Delegate Hill.
Yeah, I mean, we sort of discussed it during the hearing and maybe someone can answer it for me. I know this is a courtesy bill, but we've taken positions before about preferences for local and how they backfire. And I guess the assumption is that Garrett's willing to take the backfire, but I just wanted to hear from the subcommittee why people aren't concerned about that, the local preference shooting first, because I thought there were going to be maybe some changes to the bill. But obviously, people think this is great and not a problem. I'm just interested before we go on the committee for myself, so I don't have to ask there, why are we okay if we give a local preference type of scenario?
Delegate Shalega, do you have something to add to that?
Yeah, I was just gonna say, I thought we learned in the hearing there are a couple other counties that do it. And, certainly Delegate Hill, I understand your concern with not supporting some local bills that generally we just vote for on the floor. And yesterday I voted against two Prince George's County local bills, one of which raised a sales tax, a fee on cell phones. I don't remember what the other was. So, there is an opportunity to vote against local bills that you don't like on the floor.
Okay, thanks to Delegate Shalega. I thought that the testimony was that the other jurisdictions have if it happens to us, then we'll do it. I didn't think they were, at least that's as I remember the testimony, they weren't shoot first local preferences.
Delegate Alston?
Okay, sorry, having some technical issues this morning. I was going to say, I actually don't mind personally the local preferences because we need to be encouraging our small local businesses and helping them out financially. I was actually going to inquire if we could amend Prince George's County onto the bill. I don't want to mess with their local bill, but I would definitely be interested. I'll ask the chair before the vote session about that because I know that several local businesses in our county have been outbid by larger companies from other counties, and it's making it difficult for them to continue to work when people are coming from either out of state, out of county, and a lot of times out of county, almost from the far side of the state to do business that local businesses used to do. So I actually think it's a good thing to support the local economy and the local ecosystem. So thank you.
You're welcome. Lindsay, do you have any information on what other counties are doing?
I do. There are 11 counties that have some sort of local preference, and Delegate Hill's right. Some of them are reciprocal in nature. Some of them are not reciprocal, but limited to certain types of contracts. There are 4 counties that have preferences that are not reciprocal and that are not otherwise limited, like Calvert's proposing here. Those are Caroline, Cecil, Charles, and Queen Anne's. To Delegate Alston's point, Prince George's County does not have any kind of local preference, but I would strongly encourage you not to try and amend onto a Calvert County delegation bill in this particular instance, and probably seek a bill next year for Prince George's County.
Thanks, Lindsay. Delegate Chisholm?
Thank you, Mr. Chair. I'm just curious, Delegate Hill said that this has backfired on us before, and I just was curious if she had any examples.
Delegate Hill?
Yeah, no, in other jurisdictions, what ends up happening is then your businesses don't get to bid in other jurisdictions. So if you're in Garrett County and they're giving first preference and the neighboring county has a bid and you've got a vendor, they may say, well, we're not. And that's why a lot of the ones, and thank you, Lindsay, for that clarification, because my notes, again, from the hearing are that, some other jurisdictions have local preferences, but they seem to be reciprocal, not unilateral. So it's good to know that there are some other unilateral ones, and this would not be precedent setting. And since it's not precedent setting, my concerns are lessened. But that Delegate Chisholm, that's what we have seen, and I can't give you the specifics, but I remember this discussion over the years here in this committee on similar bills.
Okay, thank you.
Delegate Kaiser.
Thank you, Mr. Chair. In terms of what Delegate Alston said, and then how Lindsay's response, I think typically when someone has a local bill and other jurisdictions want to get on, it has happened on the floor, but it usually happens with like a delegation letter. So just making that suggestion.
Okay, thanks for the suggestion. Delegate Johnson.
Thank you, Mr. Chair. And this bill is just enabling. It doesn't require them to hire the local contractor or local, correct?
That's right. It's authorizing the Board of County Commissioners to enact the ordinance. And also just to clarify, so Calvert is a commissioner county. The other counties that I mentioned that have a non-reciprocal preference are either code, home rule, or charter counties, which is why they've been able to do this at the local level without coming to the state in the first place.
Right, thank you.
Thank you. Now, let me just double check on this vote because I had thought that it was unanimous. Let me just check. Is everyone okay with this, moving this bill forward? Okay, I'll record the vote as unanimous then, and we'll bring this to the full committee. That completes our work, doesn't it, Lindsay? Okay, thanks everyone very much for getting up this morning and coming in early. I think we're probably all caught up, but I suspect we will meet at least one more time.
We did just hold a bill.
Oh yeah, we just hold the bell. All right, we will meet another
We have
time.
commemorative bills this afternoon.
Oh, okay. All right, well, I'll see you all soon. Thanks, everyone. We are adjourned.